Members, we now turn to the Objectionable Publications and Indecency Legislation Bill. The question is that Part 1 stand part. I call Jacinda Ardern.
Thank you, Mr Chair. It's my pleasure to take a call on the Objectionable Publications and Indecency Legislation Bill, and I'm glad that the Minister will be in the chair for the debate around Part 1 and also around one of the recent SOPs that has been tabled in her name. I want to focus, though, firstly on the substantive clauses within Part 1 which make the most significant changes to this bill. Before I do, though, Mr Chair, I want to make the general comment that these are amendments to a piece of legislation that has broader effect than simply objectionable material as it relates to children. And I think that there has been some discussion, perhaps within even the committee, select committee, but certainly within our party, over the need for an overall strategy when dealing with objectionable material, child exploitation, and so on as it relates to children. And it feels like this is a piecemeal approach to what is a much wider and very substantive issue. But that's just a contextual point that I wanted to make before getting into some of the detail on this bill. I want to start, Mr Speaker, by looking at Clause 4 of the bill, which amends Section 124 and relates to offences involving knowledge in relation to objectionable material. This is the clause which, the first clause which alters the penalty regime for essentially the supply or distribution or the making of objectionable material and by way of exportation from New Zealand. I think the point that it's important to make here, as I said in my introductory comments, because this legislation is an amendment to the Films, Videos and Publications Classification Act, there is a fairly wide interpretation around the term objectionable. Now, the reason that that's important is because most people's mind, and certainly when the Select Committee was considering this, children, the effect on children was the primary consideration. So when the committee decided that it was right that a maximum term of imprisonment for an offence involving objectionable, the supply and creation of objectionable material involving children would move to 10 to 14 years, that's who they had in their minds at that time. But as the Select Committee, I think, rightly pointed out, because we don't have specific child exploitation offences, the term objectionable is still relatively open and up to the discretion of the Film and Literature Classification Office. So, bit of a debate at the Select Committee level as to whether or not actually we should be dealing with a separate piece of legislation or whether leaving that discretion around objectionable was the right way to go. I think that probably the point that the Select Committee makes that's of the most relevance is that it becomes very difficult then if you're creating separate legislation that just applies to children to where you draw that line. For instance, would you say that it would relate to objectionable would mean anything that was exploitative as it related to a young person, which means that you would probably go from 14 to 17, or would you say simply a child, which therefore under existing definitions would only take you to the age of 14, for instance? You start then having to get into some of those arbitrary lines. I think the example that's raised by the Select Committee was, for instance, for example, it could be argued that material depicting sexual violence against women also warrants higher penalties. So I certainly understand the justification of the Select Committee by leaving it somewhat open-ended in terms of determining what is objectionable and just allowing them to be as consistent as they can be. I think it's slightly disappointing, though, that we don't, for instance, have a body like a Sentencing Council who would be able to ensure that we have consistency in the application or the determination of what that definition of objectionable is, whether or not those maximum penalties are being used appropriately or as Parliament intended. We come time and time again in the House to examples where I think a sentencing council would really prove their worth. Mr. Chair.
Jacinda Ardern.
Thank you. And I think this is another example where, given that we're allowing that discretion, it would have been useful. I also would like to ask the Minister and the Chair whether or not any consideration was, if we're not going to be as definitive as to point out the child within the definition of objectionable, whether or not it was considered that embedding that as an aggravating factor at the point of sentencing was another way that perhaps you could create that point of difference in the legislation. I would be interested to know if that was ever considered, because that might have been an elegant way to deal with some of those definition issues. Also interested in how many cases we know have fallen into the category of perhaps being objectionable but not relating to children. So how broadly is that definition applied for this penalty regime? I think that might have been information provided at the Select Committee which would be useful. The other issue that the Select Committee raised was, if in raising the penalty regime from 10 to 14 years, do we get into a situation where the supply or creation of material actually becomes a higher penalty regime than, for instance, a physical assault against a child? Making sure we have that consistency in the legislation. It's a very important point to make. I took a quick look. If you take a quick example from the Crimes Act, sexual conduct with a child under 12 has a term not exceeding 14 years. Again, I think it is important to make sure that we have laws that are consistent. Again, advice, I think, from something for the likes of a sentencing council would have been in the position to take a broader view as to whether or not we have got a proportionate response in every element of the law as it relates to the abuse and exploitation of children. And so, look, in and of its own right, of course, anyone looking at this law would say, yes, it's right to have those maximum penalties lifted, and we would agree with that. But it is important, I think, that we make sure that the other offences that relate to harm to children keep pace with the expectations of Parliament as well. And again, hard to do that from within Parliament, and so a sentencing council would have proved its worth there. Clause 5, Mr. Chair. These are the new subsections which talk about possession of an electronic publication. A really important point here, obviously in the drafting, have been very particular to make sure that you do not have to have material literally saved onto your device in order to be considered possession. I think that's incredibly important that we make sure that we're really clear on what possession is considered to be. I understand that there was a case which I think was the rationale for making sure that this was stepped out very clearly. Merrick versus the police, I believe that was a case that actually involved an ex-police officer, if I'm correct, in his possession of objectionable material. I found it hard finding some substance around that case. If the Minister was willing to speak to how the bill is now into alignment with the outcome of that case, I'd be very interested, because I found it hard to find details online, Mr. Chair. Clause 6, though, I wanted to come to that because that relates to offences of possession. So not just supply, penalty regime increasing, but also possession. And it makes sense that if you're lifting one that you would consider lifting the other. We're looking at amendments now which will increase maximum valuable term from 5 years to 10 years. Again, keeping alignment with other regimes, I think, is incredibly important. But from the Select Committee report, it doesn't seem to be the main concern of all the things that they have raised. Some concern, however, Mr. Chair, was raised on Clause 7. Now, this clause sets out a specific expectation that if there is a repeat offence, that the presumption from the court be to hand down a jail-based sentence. Now, you can absolutely understand why there would be the view that we would need to send a strong signal. We are talking about a very specific classification of offending. There are some principles which apply to this type of offending which are specific to child exploitation and the circulation of objectionable material. I'll take another call later.
I call Claire Curran.